You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. I'm your host, Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This episode is Help! My co-inventor refuses to sign the patent application. So picture this. You've come up with a killer invention, maybe a new type of foldable drone that transforms into a pair of sunglasses. It's awesome. You're pumped. You want to file a patent application, but wait, that one friend who helped brainstorm the power mechanism over pizza one night, you realize they might technically be a co-inventor, and now they're ghosting you, or worse, they're flat out saying they won't sign anything. What now? Look, this happens more often than you think. Sometimes it's a falling out. Sometimes someone just doesn't understand what they're being asked to sign, or they think they're about to get scammed out of $1 billion idea, or they're just being difficult for no reason. Whatever the case, here's the thing. If someone is truly a co-inventor, and we'll come back to what that really means, you can't just cut them out of the process, but also they can't hold your patent hostage either. Let's take a quick breath and look how things work legally. When you file a patent application, normally everyone who's listed as an inventor has to sign what's called a declaration. It basically says, yes, I'm an inventor of what's in this application, and I authorize the patent office to process it. It's a formality, but an important one. But what happens if one of those inventors won't sign it? The good news is there's actually a procedure baked right into the patent rules for this exact situation. So if you're filing a patent application and one of the inventors won't cooperate, you don't have to scrap the whole thing. You can still move forward, but, and this is important, you have to prove that you made a real effort to get that signature. It's not like you could just say, I didn't feel like calling them. What you'll usually do is file what's called a substitute statement. It's basically a sworn declaration that says, we tried, they refused, or we couldn't reach them, and here's how. You need to show what you tried in good faith. Maybe you emailed, called, sent letters, whatever. And you attach all of your filings. The patent office doesn't want people skipping inventors lightly, but they also don't want one person to block progress for everyone else. Now let's rewind a second because I mentioned something earlier that matters big time here. What exactly is a co-inventor? Just because someone gave you a cool idea over lunch doesn't automatically make them a co-inventor. You've got to be careful about who you list. A co-inventor is someone who contributed to at least one claim of the invention, not just the background, brainstorming, not just, hey, wouldn't it be cool if, but actual conception of a claim-worthy element. If someone didn't contribute to the specific subject matter being claimed, they're not a co-inventor. That's a legal line you really want to get right. Too many inventors is bad, and too few is worse. But if they are a true co-inventor and they're just refusing to play ball, that's where this procedure comes in. Let's say you're working with a patent attorney, hopefully someone like me, and you figured out that the person really does count as a co-inventor. You've got the draft application, and now it's time for signatures. You send the documents, nothing. You follow up, still nothing. Maybe you even get an angry text saying they're not interested and never contact them again. At that point, you're allowed to use the procedures under what's called 37 CFR 1.64. That's the one that covers the substitute statement for a non-cooperative inventor. Now, one thing I get asked a lot is, well, what if I just don't want to list them at all and hope no one notices? Yeah, don't do that. Failing to name a true inventor is grounds for invalidating your entire patent. It's called inequitable conduct. And if someone later proves that you intentionally left the co-inventor off, not only could the patent get canceled, but you could also run into some pretty ugly legal and ethical issues. So don't try to play cute with the list of inventors. It's not worth it. Also, let me clear one thing up. Signing the declaration doesn't mean someone is giving up their rights to the invention. It just means they're agreeing that they're an inventor. Ownership and inventorship are two totally different beasts. You can be an inventor and not own any rights. You can assign those rights away to a company or a co-founder or anyone else. But the declaration, that's just about telling the truth to the patent office. So if your co-inventor is worried that signing something will make them lose their stake, you can reassure them that's not what the declaration does. Another thing that tends to come up in these situations is money, or more specifically, fear of money. A co-inventor sometimes refuses to sign because they think the moment they do, they're losing leverage. They worry that once the patent is filed, someone else is going to cut them out of future profits. And honestly, that fear isn't totally irrational if expectations were never discussed up front, but legally, refusing to sign doesn't actually give them extra power. It just slows things down and creates more paperwork. Here's a part that surprises a lot of people. Even if someone is a co-inventor, that does not automatically mean that they get paid. Inventorship is about who contributed to the invention. Ownership is about who owns the patent rights. Two separate things, as I discussed. You could be named as an inventor and still have zero ownership interest if you assigned your rights away earlier, like an employment agreement. So sometimes the refusal is really just a misunderstanding of what's happening. Now let's talk about what happens after the patent issues, because this is where things can get even more awkward. If a co-inventor never assigned their rights, they technically own an undivided interest in the patent. That means they can license it independently, even without other inventors' permissions. That's not hypothetical, that's real. So if you're dealing with a co-inventor who's already being difficult at the signing stage, that's a big red flag. It's one reason why getting assignment agreements signed early is so important, way before emotions get involved. You might be wondering whether this problem can be avoided entirely, and the answer is yes, most of the time. The best way is to talk about inventorship and ownership early, before filing, before money enters the picture, and definitely before relationships get strained. Clear agreements up front save an incredible amount of pain later. It's like a prenuptial agreement, but for inventions. Not romantic, but very practical. Another common question I hear is whether the Patent Office investigates these disputes. And the answer is no, not really. The Patent Office isn't going to hold hearings about who's being stubborn or who's acting unfairly. They just want to know whether the inventors are correctly named and whether the procedural requirements are met. If you follow the rules and submit the substitute statement properly, they'll process the application. They're not there to referee personal conflicts. That said, just because the Patent Office allows you to proceed doesn't mean the issue disappears forever. A disgruntled co-inventor can still show up later, especially if the invention turns out to be valuable. They might claim they weren't properly credited or that they were wrongfully excluded from ownership. That's when things move from patent procedure into contract law and sometimes litigation. So while the substitute statement lets you move forward, it doesn't magically erase interpersonal problems. That's why I always tell inventors to think strategically, not emotionally. If someone's refusing to sign, ask why. Is it confusion, fear, a genuine dispute over inventorship, or just a breakdown in communication? Sometimes a short conversation clears everything up, other times it doesn't. But understanding the motivation helps decide the next steps. Also, just to be clear, refusing to sign does not stop the clock. Patent rights are first to file. Waiting around for someone to calm down can cost you priority. And once priority is gone, it's gone. So there are moments when moving forward with a substitute statement is not just allowed, it's necessary. One last thing I'll mention, and this comes up in a lot of startup environments, founders brainstorm together, roles blur, ideas evolve, and then suddenly someone leaves the company. Months later, you're filing a patent application, and now that former founder wants leverage. That's a very common fact pattern. The law gives you a way through it, but the cleaner solution is still good documentation from day one. So if you take one thing away from this episode, it's this. A co-inventor refusing to sign is a problem, but it's not a dead end. The patent system anticipated the scenario. There's a process, it's manageable, but it's also a reminder that patents aren't just technical documents, they're legal instruments tied to human relationships, and humans are messy. And that's it for today's episode. I'm Adam Diament, and if you need help filing a patent application or other intellectual property, give me a call at 424-281-0162. Until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.